Good morning. Are you Ronald Spikes?
Yes, ma'am.
And Mr. Spikes is charged with the offense of manslaughter in cause number 25 DCCR 0920. Mr. Macon has filed a motion asking me.
No, he was arrested for murder and indicted for manslaughter.
Intentionally and knowingly causing the death of an individual.
Let me look at the indictment. It shows I don't know why the heading
Heading says manslaughter, but the language.
did then and there intentionally and knowingly cause the death of an individual, namely Rowan Williams, by striking him with an automobile. So at least on the indictment language, that would.
Whoa, this is a major moment. The heading says manslaughter, but the indictment language says intentionally and knowingly caused the death. That's murder. And in Texas, that difference is massive. Manslaughter is a second-degree felony. Murder? First degree. We're talking about a completely different punishment range. This isn't just paperwork, this changes everything.
Be murder. I know it's not, the headings are not sometimes important, but I think that needs to be adjusted and changed, especially if that is what is in, that's what's in Odyssey. So that's showing up on everything with the wrong stuff. So that needs to be amended if you can. Take care of that later. So based on that, it looks like the offense is actually the first degree felony offense of murder, Mr. Spikes. And Mr. Macon has filed a motion asking that I reduce your bond. Bond is currently set, thank you, currently set at $800,000. Mr. Macon, do you wish to call your client?
Yes, Your Honor.
Sir, if you'll please raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Macon.
Now, what's your name?
Ronald Spikes.
And Mr. Spikes, you're the person charged with the offense.
Yes, sir.
Do you have enough money, you or your family, to post a $800,000 bond?
No, sir, I don't.
Okay. Now, before you were arrested, I mean, in the past, you were in lots of trouble, right?
Yes, sir.
And you've got some priors, but in the last 10 years, have you been in any trouble?
No, sir, I have not been in no trouble.
Okay. And you have your wife living in this area?
Yes, I have my wife, my family, and things.
Okay, and your family, and you have a job, were you able to make bond?
Yes, sir.
And that's with your father-in-law, Mr. Gonzalez, correct?
Yes, sir. Yes, sir.
And that's at 365 Scrap.
Yeah, yes, sir.
Okay, and
An $800,000 bond tells you how serious the court views this case. Bond isn't punishment, it's about risk. Risk of flight. Risk to the community. And when someone is accused of intentionally striking a person with a vehicle, the court is calculating both.
did you also work for Zachary as a heavy equipment?
Yes, sir, I do.
So you've always been working on it?
Yes, I have,
Do you
sir.
have any assets whatsoever? Real property, coin collection,
No,
anything
sir.
like that? And you're asking the court to set some reasonable bond so you could get out and go to work?
Yes, sir.
Mr. Smith, any questions? All right, any other witnesses?
No.
Mr. Smith, what is the state's position?
Judge, he does have a prior from 1998, he was sentenced to 4 years TDC. So whatever if it's murder, he would be 15 to life at least. And if it's manslaughter, it's 5 to life. State court is reasonable for us.
Mr. Macon?
Your Honor, we think that $800,000 bond is excessive and would ask that it be lowered.
I am taking judicial notice of the court's file, which includes the probable cause affidavit, as well as there was a letter of support that was sent by Mr. Macon from a Rocky Johnson. Were you able to review that, Mr. Smith? I think it was emailed.
I believe it is.
Okay.
November 16th.
Okay. Speak up, please.
It was from November 16th of 1998 for a 4-year sentence.
All right. 2, possession of controlled substance, same date. Got it. Okay.
And here's the balancing act. The judge reduces the bond, but not dramatically. from $800,000 to $500,000. That signals something important. The court acknowledges community ties and work history, but the charge is still murder. This isn't leniency. This is controlled risk management.
What I'm going to do is I am going to grant the motion for a bond reduction. I'm going to reduce the bond to $500,000. Sir,
Nah,
did you want to say that again louder?
I don't think I ain't saying that. I ain't saying that.
You did say something.
Well, I was like, well, I didn't say nothing to it.
I'm going to reduce the bond to $500,000. A condition of that bond would be, if you make it, that you are on house arrest and required to wear a GPS monitoring device at all times. And we will get the case set for an announcement as quickly as possible. All right? Sir?
Yeah, I was like,
That's what it's set at right now. All right? You can go back with the bailiff.
can I ask one question too?
What?
I'll be back.
All right, are you LaCaven Jenkins?
Yes, ma'am.
And Ms. Perazzo, will your client waive the formal reading of the indictment in each case? Mr. Jenkins, in cause number 24, DCCR 1026, you're charged with the first-degree felony offense of aggravated robbery, and that is from March 3rd of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Catch the conditions. House arrest. GPS monitor. That means every movement is tracked. You're not just out, you're watched. In high-level felony cases, judges often stack bond conditions like this to minimize risk. Freedom, yes, but with a digital leash.
Yes, ma'am.
And then, in cause number 24, DCCR 1027, you're charged with the third-degree felony offense of fraudulent use or possession of identifying information from March 12th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? Answer out loud for me, thank you. And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents in each of those cases that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Perazzo?
Yes, ma'am.
And do you fully understand that? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Jenkins is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas.
8 years in the institutional division of the Texas Department of Criminal Justice. That's real time. And notice, this was a negotiated plea. Meaning both sides agreed this was the outcome. Trials are risky. Plea deals are calculated certainty. He chose certainty.
In cause number 24, DCCR 1026, find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon in that case. And then in cause number 24, DCCR 1027, also find sufficient evidence to find you guilty, and at this time find you guilty of fraudulent use or possession of identifying information. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you, in each of your cases, the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Perazzo. All right, good luck to you, sir. You can go back with the bailiff. Thank you, Ms. Perazzo.